Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Although it already seems like a lifetime ago, earlier this week, a former president of the United States went on national television and spread unfounded lies that Haitian immigrants in Springfield, Ohio are eating pets. Uniformly, it has been shown that there is no evidence whatsoever to support this lie, and yet a former president of the United States said it on national television, as of course did his running mate. But even if something happened, what is the significance? That a couple of immigrants did something bad that conflicts with US culture? Again, zero evidence even hinting that this actually happened. But of course, true or not, the reason J.D. Vance and his would-be boss honed in on this is to paint immigrants, and especially black immigrants, with a broad brush, showing that they are dangerous people who are not like us and can never be. Also, probably an effort to create a national enemy and to stoke division. And well, if you can condone political tactics like this, I don't know what to tell you and don't really want to know you. Also, and if self-interest is your motivating character trait, check your history to see what happens next after you start labeling whole chunks of people as irredeemable enemies of the state. Usually doesn't stop with the first group. The internet is creating some excellent humor-based content around this though, so at least there's that. But as I saw Laura Kelly post on Facebook, can you imagine being a Haitian or Haitian American child walking into school in Springfield, Ohio this week? Or really anywhere? These words have an impact. Ever since the debate on September 10th, I've been checking the Instagram feed of the Family Action Network movement, FAM, perhaps the most impactful Haitian and Haitian American advocacy nonprofit in Florida, if not the United States. IRA and KKTP have a long history with FAM, as do I, although not quite as long, of course. I was looking for something to repeat on the podcast, but even as I was searching FAM's feed, I felt a bit weird. Why are victims so often looked to as the voice to combat their victimhood? I am just as qualified as FAM to say that the former president, his would-be vice president, and their allies repeating this vile lie and using this political strategy are disgusting, right? Well, I guess it's on me, because the only post that FAM has made since the event is as follows, quote, "Here at FAM, our hearts go out to the families who lost loved ones on 9/11. Today we remember and honor the lives lost and the strength of their loved ones," end quote. I'll take them over the former president any day. Links to FAM in the show notes. 3 cases for you guys. Interesting and important, of course, and I hope that you enjoy them. Our first case is Castellanos-Ventura v. Garland, published by the Second Circuit on September 13th, 2024. This case is about the unable or unwilling to protect element required to get asylum in the United States. And if you hear a baby crying in the background every so often in the podcast, well, The podcast has entered a new era, and we're going to just have to live with that. I'll do my best to keep him out, though. Ms. Castellanos-Ventura is an asylum seeker from Honduras. The particular social group she asserted before the immigration judge of the BIA was the group, quote, Honduran women, end quote. And wouldn't you know it, the BIA assumed, without deciding, that the group is viable. It's also uncontested that Ms. Castellanos-Ventura was abused terribly, much of which occurred when she was a child. By her mother, stepfather, grandfather, and uncle. It's horrible. Not only that, quote, she was threatened and raped multiple times by a local contract killer after she moved out of her family home, end quote. What the actual hell? She never reported any of this because she didn't think Honduran authorities would help her. But also, right, she was a child for some, if not most of it. But that's what the IJ emphasized after assuming that the particular social group was cognizable. No showing that the Honduran police were unable or unwilling to protect her, so no past persecution showing, so no presumption of a well-founded fear of future persecution. Plus, reasoned the IJ, her mother, quote, secured a restraining order against one of the sexual abusers, and also observed that the Honduran government worked to protect victims of rape and domestic violence, end quote. The BIA affirmed. The Second Circuit did not. Recall, even if an asylum seeker doesn't fear or hasn't been harmed by a country's government, quote, private acts can also constitute persecution if the government is unable or unwilling to control such actions, end quote. The IJ and the BIA assumed everything favorable for Ms. Castellanos-Ventura here, except the unable or unwilling to protect prong, and that finding largely hinged on her failure to report all the terrible things to the Honduran police and to give them a chance to then protect her. A quirky pseudo-requirement that has kind of developed in asylum over the years. But recently in many circuits and even the BIA, quoting matter of CGT from episode 176, quote, failure to report harm is not necessarily fatal to a claim of persecution if the applicant can demonstrate that reporting private abuse to government authorities would have been futile or dangerous, end quote. Now maybe it's because CGT wasn't published yet, or maybe not, I don't know. But here the IJ and the BIA, quote, failed to consider whether it would have been futile or dangerous for an abused child, such as Ms. Castellanos-Ventura, to seek protection from the authorities, end quote. Standards also from CGT that I strongly emphasized on the podcast, if I recall, at the time. Keep CGT in your back pockets at all times. The Fourth Circuit said something similar, by the way, and lots more regarding harm to children and Portillo Flores v. Garland. Explained the Second Circuit, episode 62, and en banc, no less. The Second Circuit also saw error in the fact that, to find that the Honduran government was making efforts to protect people like Ms. Castellanos-Ventura, quote, the agency relied on one page of the Department of State's 2017 Human Rights Report addressing rape and domestic violence against women, end quote. But there was other evidence to the contrary in the record, and in that very Department of State report. And so, well, the BIA erred, quote, by relying on only this one source, without acknowledging or evaluating conflicting evidence, end quote. Can't do that. Plus, Ms. Castellanos-Ventura's harm was suffered as a child, meaning that the unable or unwilling to protect analysis was more nuanced. How did the Honduran government do at protecting children from intrafamily violence? Ms. Castellanos-Ventura presented evidence on that nuanced issue, so the failure of the agency to consider that evidence was further grounds for a remand. That evidence was from the Immigration and Refugee Board of Canada, by the way, no less. Seems like quite the well evidentiarily supported case, and a tough one at that. And this is just me, but isn't there case law out there that stands for the proposition that harm suffered as a child can be persecution, even if that same harm wouldn't cut it when the individual was an adult? Hint, there is. But anyway, it was all assumed away anyway, right? The only thing is unable or unwilling to protect. And now that's going back for further analysis. Meaning, congratulations H. Esteban Figueroa Brucey for petitioner. Seems like a hard-fought win. Two more things. First, if you think you have a decision that might be good for other non-citizens, by all means, ask the circuit to publish it. Here, quote, our decision in this matter originally appeared in an unpublished summary order issued on July 11, 2024. Ms. Castellanos-Ventura subsequently moved to have our decision published. Because we are persuaded that this decision may be helpful to guide future cases if it has some precedential value, we grant the motion and publish our disposition." End quote. I, for one, would have never known. You too, probably. And unrelated to all this, but also on Friday from the Second Circuit, the court held in the illegal reentry context that a deficient notice to appear does not have jurisdictional implications, and that the illegal reentry criminal statute is constitutional. Both things that all circuits who have addressed this issue thus far have held. And that is Castellanos-Ventura v. Garland. Our next case, you're not going to believe it, is Patel v. Garland, published by the Sixth Circuit on September 10th, 2024. Wouldn't you know it, it's a Patel decision about jurisdiction that heavily implicates and relies upon, well, Patel v. Garland, the Supreme Court's version, that is, and unrelated. Judge Blumkatz dissented. Miss Patel is from India, quote, "She claims in her opening brief that she entered on March 3rd, 2000, and that she did so with the help of an Indian movie star, Shanti Priya, known as Shanti Ray to the public, by posing as her nanny during a trip to the United States," end quote. Interesting. Miss Patel eventually met her husband in the United States, and they had 3 U.S. citizen children together. Her husband filed an employment-based I-45 in 2007, and Miss Patel's attorney prematurely filed an application for her as a derivative, too. And because of that, well, USCIS put her in removal proceedings. Because after all, she didn't have status. Before that, actually, it's pretty complicated. In that I-45, Miss Patel said that she entered the United States without inspection near Buffalo, New York on March 31st, 2000. She said the same thing during a USCIS interview. This despite, again, that she's saying in this case, that she entered with inspection and admission, albeit possibly fraudulent. All of that, though, means Miss Patel's in big trouble, as is that lawyer. Because, right, she's applying to adjust status and admitting that she doesn't have an inspection or admission. Not only that, during this I-45 process, USCIS itself then told Miss Patel that, quote, it was in possession of a tourist visa in her name issued January 6, 2000, which listed her as a domestic employee of Miss Ray, end quote. Again, as everyone listening to this probably knows, whether Miss Patel entered the United States with a visa or alternatively unlawfully is dispositive of whether she can adjust to LPR status in the U.S. in the first place. So it's an important detail, and it's one that Miss Patel is actually undermining herself on before USCIS. In response to USCIS's RFE, or NOID, unsure, Miss Patel admitted that she had lied to USCIS, but said that she did so out of fear of what the Indian movie star would have done to her. Then she produced a copy of that January 2000 visa. So there you go. I guess she has that inspection and admission. Adjustment of status was still denied, though, because her husband's application had not been approved yet, as I mentioned. So now she's in removal proceedings. Seems pretty clear, though, that she was inspected and admitted, albeit through fraud, and that she further misrepresented that issue to USCIS, even though that latter misrepresentation actually probably did more harm than good, legally speaking, to her ability to adjust to LPR status. So dare I say that that latter misrepresentation about how she entered the US was immaterial? Couldn't have helped her. It's a cute argument. And it's immaterial to this decision. Looks like her husband did eventually obtain LPR status, and so Ms. Patel filed to adjust in immigration court. But eventually, her immigration attorney conceded in removal proceedings the charge in the NTA that she had entered without inspection or admission, which is somewhat incredible, although apparently the attorney was later, quote, able to correct the record, end quote. It appears that even DHS was assuming she had entered lawfully, but they opposed adjustment of status in the first immigration court, arguing that she had done so, that is, entered fraudulently. So Ms. Patel filed a Form I-601 waiver to waive that fraud, which requires an extreme hardship showing to her LPR or U.S. citizen husband or parent. DHS conceded her statutory eligibility for this waiver, apparently. But then venue was changed to the Louisville, Kentucky Immigration Court on Ms. Patel's request. In those new changed proceedings, DHS asserted that actually she entered IWI, and oh by the way, Judge, her attorney conceded it. Noting a lack of evidence in the record, even though USCIS appears to have had much of it, right, the IJ then sustained the IWI charge in the NTA. By this point as well, the husband's a U.S. citizen. What a mess of a case. But again, didn't USCIS and Miss Patel have her visa? I'm confused. Miss Patel also testified all about getting smuggled in to the United States by that movie star with a tourist visa. But also her story in immigration court was a bit different than the one that she told USCIS, even when she came clean. But again, don't the visas exist? She testified that she entered in March 2000. Some discrepancies, though, it seems, and ultimately, quote, the IJ essentially threw up his hands, stating he doesn't know what to believe regarding Miss Patel's story, end quote. Importantly, the IJ held that the negatives far outweighed the positives in her case and denied the I-45. The BIA affirmed. And well, the Sixth Circuit threw up its hands too. It said Patel, of the different variety, barred it from reviewing the issue. Both an I-601 and an I-45 are the type of reliefs listed as being potentially barred from federal court review at INA Section 242A2B and are squarely addressed by the Supreme Court's Patel decision a few years ago. Here, the Sixth Circuit viewed the issue in a manner a bit convenient to bar jurisdiction, or maybe the IJ held in such a way, I'm unclear. But in any event, to the Sixth Circuit, the manner of entry dispute wasn't really about whether Miss Patel was eligible to adjust to LPR status, because it gave her, or didn't give her, an inspection and admission. Rather, explained the Sixth Circuit, to obtain an I-601 fraud waiver or to adjust status, Miss Patel had the burden, the factual burden, to establish where and how she entered the United States. To the Sixth Circuit, the IJ and the BIA held that she had not met that factual burden, which to the court is a factual dispute, and one that hinges on Miss Patel's credibility at that. Having framed it like that, that may be an issue, and to the Sixth Circuit is an issue, that it cannot review when tethered to a fraud waiver or I-45 adjustment of status application because of the Supreme Court's Patel decision. I mean, heck, recall, Mr. Patel himself in Patel was applying to adjust status, but was deemed inadmissible because he was deemed not credible about whether he had made a false claim to U.S. citizenship or not. In response, Miss Patel alleged ineffective assistance of counsel and that the Louisville IJ had not given her a fair hearing. The Sixth Circuit rejected both arguments, although I guess it assumes that it had jurisdiction over them. But it first held that neither of them were exhausted before the BIA, nor in any event did the facts now alleged show judicial bias by the Louisville IJ, said the court. To the Sixth Circuit, as proceedings remained ongoing, there was no final decision on Miss Patel's manner of entry when the matter was transferred to the Louisville Immigration Court. That the Louisville IJ saw the record differently does not equate to judicial bias, explained the Sixth Circuit. Miss Patel also argued, however, that this particular IJ declines cases all the time above national averages, quote, weaponizes the immigration court proceedings as a mechanism for deportation, end quote, and that the transcript before the Sixth Circuit doesn't reflect the IJ's true hostility. Wowzers. But the court didn't see sufficient evidence in the record. And remember, said the court, Miss Patel was definitely untruthful at least once, and maybe more than once. Having held that it lacked jurisdiction to review the issue or issues in dispute, the Sixth Circuit then said that nevertheless, quote, a significant error haunts this case, end quote. Specifically, the IJ chastised Miss Patel for presenting her visa and I-94 entry document. I guess with that March 2000 date, right? And the IJ believed that that was different than the visa presented by DHS. And the IJ went so far as to recommend that FDNS investigate Miss Patel for fraud. The IJ thinks that her visa and I-94 might be fraudulent. Quote, but this concern rests on a fundamental error. The government never entered a copy of petitioner's visa into the record. Instead, we have two government exhibits, the letter USCIS sent to petitioner requesting that she clarify her manner of entry, and an I-797A form supplying petitioner a replacement copy of her original I-94. Nothing else, end quote. So there isn't actually conflicting visas or conflicting I-94s in the record. Not only that, explained the Sixth Circuit, that Miss Patel may have received a visa in January 2000 doesn't mean that she entered in January 2000, as all immigration attorneys know and as the Sixth Circuit points out. It is completely plausible and indeed expected that she would have received her visa in January 2000, but not entered until March 2000, as she was testifying to. And again, there is no conflicting visa or I-94 in the record, explained the Sixth Circuit. Indeed, quote, the visa petitioner offered shows that it was issued on January 6, 2000, and that she entered the country as the domestic employee of Miss Shanti Ray. Not only does petitioner's visa not contradict any government visa, it actually matches the USCIS letter in every respect, end quote. So it looks like the IJ and even oil messed up and misunderstood a pretty important issue, explained the Sixth Circuit. And of course, there's absolutely no way that the IJ wasn't influenced by the apparent mistaken belief that Ms. Patel may have submitted a fraudulent visa and or I-94. Quote, it is more than a little disturbing that such sophisticated parties do not appear to know the difference between an I-94 and a visa, particularly when the forms are so visually different. Ultimately, however, this error was only part of the IJ's reason for denying relief, and the decision was within his discretion on the grounds of petitioner's other falsehoods. We merely flagged this error as guidance for future proceedings, end quote. This is the world we live in after the Supreme Court's Patel decision. And Miss Patel lost her case. And the dissent? Judge Blumkatz took this, quote, significant error, end quote, and ran with it in dissent, as you might have guessed. Believing it jurisdictionally significant, the dissent writes that this was not merely an unreviewable factual dispute, but a, quote, legal error that infected the IJ's view of Ms. Patel's credibility and was so central to his decision that it was repeated by the BIA and defended vigorously by the government on appeal, end quote. Not to mention that Ms. Patel has been here for 24 years, noted the judge. But the dissent is just that, the dissent. And that is Patel v. Garland. Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes. Attention lawyers looking to dive into immigration law. Are you ready to master the art of marriage-based immigration? Introducing the Ultimate Marriage Green Card Course, a comprehensive resource by John Khosravi, founder of the Immigration Lawyer's Toolbox, to kickstart your journey in family-based immigration. His course offers 18 hours of engaging video content and includes monthly office hours for your questions. You'll analyze and learn, through the statutes, regulations, case law, and real-life practice, essential topics like 212 inadmissibility, 245 adjustment, consular processing, and the affidavit of support requirements. The course will also cover practical office procedures, consultations, and sales techniques. Plus, you'll receive helpful samples and templates to streamline your practice. As a limited-time special bonus, the Immigration Lawyer's Toolbox is adding the recordings of an all-day O1 seminar with the best O1 lawyers in Los Angeles. Go to immigrationlawyerstoolbox.com and click on the course link, or email John at info@immigrationlawyerstoolbox.com to sign up. Reference me, Kevin, or the Immigration Review Podcast and get an additional 10% off. Or, of course, click on the link in the show notes. We conclude with Lopez v. Garland, published by the Ninth Circuit on September 11th, 2024. This case is about crimes involving moral turpitude, and it is our first true deference decision post-Loper-Bright. So, while it makes me want to cry, it's an important one to review and remember. Mr. Lopez has lived in the United States since being brought here from Mexico at about 2 years old. His mother was fleeing his terribly abusive father, quote, brutal, end quote, in the words of the Ninth Circuit. Mr. Lopez actually eventually received T5 non-immigrant status as the derivative beneficiary of a family member who had received a T1 trafficking visa, but Mr. Lopez, quote, inadvertently allowed his T5 status to expire, end quote. Guess I don't know enough about T5s. I'll look into it. So here he is then, I guess, living without status in the United States, but also having lived here since 2 years old. And then at 21 years old in 2019, Mr. Lopez was arrested while driving a friend's car that turned out to be stolen. The subsequent investigation resulted in a lot more charges. Mr. Lopez, quote, pleaded guilty in September 2021 to the felony weapons charge and 4 municipal charges of petty larceny under Section 8.10.040 of the Reno Municipal Code, in exchange for dismissal of the remaining charges, end quote. Served 14 months in prison. Seems to me that DHS might have been able to establish removability for a few reasons, but the one that they chose was that Mr. Lopez had been convicted of 2 or more CIMTs, not arising out of a single scheme of criminal conduct. And notwithstanding that weapons conviction and all those bad charges, this actually comes down only to the 4 petty larceny convictions under Reno Municipal Code Section 8.10.040, which I'll refer to as RMC, as did the Ninth Circuit. Is that statute a CIMT, Municipal Code Petty Larceny? If it is, Mr. Lopez is probably removable. An IJ found that the statute is a CIMT and then denied asylum and related relief and protection. And even though this case is mainly about crimmigration, I must note this among other things. Mr. Lopez, quote, argued that he suffered past persecution in utero based on his father's abuse of his mother during her pregnancy, end quote. Wow. But I mean, hey, if states have fetal personhood statutes, can't they suffer past persecution? Surely what Justice Alito had in mind in Dobbs. The BIA affirmed removability and denial of relief. In this published decision, the Ninth Circuit first affirmed removability, and much of that comes down to the BIA's decision in matter of Diaz-Lizaragga. See, the Reno statute at issue here, likely indivisibly and clearly, does not require as an element an intent to permanently deprive the victim of property to be petty larceny. But for decades, such a showing was required for a theft-type crime to be deemed a crime involving moral turpitude. No longer, said the BIA in Diaz-Lizaragga in 2016. Now the CIMT definition includes, quote, an intent to deprive either permanently or under circumstances where the owner's property rights are substantially eroded, end quote. And that was done by the BIA in an effort to make more people removable for petty things. All circuits to my knowledge who have reviewed Diaz-Lizaragga have held that the BIA's new definition is probably okay, but can only be applied to crimes convicted post that new definition from 2016. But that's what we have here. But also, all those other decisions, finding Diaz-Lizaragga probably okay prospectively, relied on Chevron deference. The CIMT definition, of course, being the quintessential ambiguous phrase that thus requires deference to reasonable interpretations. No longer, though, of course. Loper-Bright destroyed Chevron deference. What to do without Chevron? Well, the Ninth Circuit explained that we're back to Skidmore deference from 1944. Precedential BIA decisions, it would appear, are, quote, entitled to respect, end quote. Respecting Diaz-Lizaragga, the Ninth Circuit held that RMC Section 8.10.040 is a CIMT. Not quite bringing jurisprudence back to the colonial era as some justices desire, but close, quote, as the Supreme Court explained in Skidmore, agency decisions, while not controlling upon the courts by reason of their authority, do constitute a body of experience and informed judgment to which courts and litigants may properly resort for guidance, end quote. Federal courts must still independently decide what the statute means, here the CIMT definition, I guess, but also, quote, the weight of such a judgment in a particular case will depend upon the thoroughness evident in its consideration, the validity of its reasoning, its consistency with earlier and later pronouncements, and all those factors which give it power to persuade, if lacking power, to control, end quote. Man, if you thought Chevron was mushy. The Ninth Circuit panel saw Diaz-Lizaragga as such a case. Yes, it marked a change in the BIA's long-standing understanding of what a CIMT is, but also, the BIA surveyed contemporary state and federal laws and, quote, concluded that criminal law has since evolved to recognize that many temporary takings are as culpable as permanent ones, end quote. For this and other reasons, the BIA's decision was thorough and well-reasoned, explained the court. It also aligned well enough with prior Ninth Circuit decisions, although no real explanation on why something like petty theft is, quote, base, vile, or depraved, end quote, as the general CIMT definition requires. Restated, why are we assuming after Chevron that theft-type crimes, even petty ones, are always base, vile, or depraved just because the taking is sufficiently significant enough? But for what it's worth, explained the Ninth Circuit, even Diaz-Lizaragga recognized that, quote, it is still appropriate to distinguish between substantial and de minimis takings when evaluating whether theft offenses involve moral turpitude, end quote. Again, though, I'm still a bit unclear why theft, as opposed to maybe, say, assault and other crimes, is almost categorically considered base, vile, or depraved in American society. Maybe another case will do a deep dive post-Loper-Bright. But this is not that case. All that's left here is to apply that Diaz-Lizaragga definition to the Reno crime, the statute of which in turn incorporates the word, quote, deprive, end quote. And both the Model Penal Code and Nevada state law define deprive as a, quote, withholding that is either permanent or for so long that a substantial portion of its value to the owner is lost, end quote. To the Ninth Circuit, that does not involve de minimis takings and does include takings that substantially erode the owner's property rights. Hence, a CIMT under Diaz-Lizaragga, though again, no discussion of its baseness, vileness, or depraved nature. That would be the end of it, except counsel made a wild argument that I'd very much like to make going forward. See, certain grounds of removability at Section 237 do not apply if a non-citizen obtains a gubernatorial or presidential pardon. They can be waived. Rare as pardons are, the 2 CIMT provision at Section 237A2AII is one of them. But the petty theft offense here is a municipal offense in Reno. Quite frankly, further showing that it's not base, vile, or depraved, right? And municipal offenses from Reno can't be pardoned by the governor of Nevada, apparently. So, counsel argued, because Mr. Lopez is unable to potentially utilize the INA's pardon exception, DHS should not be able to remove him for committing 2 municipal Reno petty theft crimes. And that is quite the argument. The Ninth Circuit disagreed. The court first goes through the INA's very interesting pardon history. And Mr. Lopez's attorneys are smart. Apparently the BIA made the very holding that they're arguing for in matter of Castellanos in 1968. And before you roll your eyes, remember, the Skidmore decision that we're relying on is published in 1944. The problem to the Ninth Circuit, though, is that the BIA overruled Castellanos in matter of Nolan, 1988. Again, no Chevron deference for either of those decisions, that is, Castellanos or Nolan, so the Ninth Circuit looked to the INA statute on its own. To the court, quote, the plain language of the statute provides only that relief is available when the petitioner has been granted a full and unconditional pardon by the President of the United States or by the governor of any of the several states, end quote, 50 to be exact. The statute does not indicate that a pardon must be available. Quote, if Congress had intended the pardon waiver to include crimes for which no pardon was available, it could have easily said so, end quote. Fair enough. The final crimmigration argument that the Ninth Circuit rejected was Mr. Lopez's argument that his petty larcenies were, in fact, committed in the same scheme of criminal conduct. So they can't make him removable under this removability provision. Now, apparently the petty larcenies were all on different days. Mr. Lopez argued that they were all part of the same crime spree. Such an interpretation of what a single scheme is conflicts with precedential BIA decisions and the Ninth Circuit's decision in Zizoni v. Whitaker from 2019. And that Ninth Circuit decision relied on Chevron deference. However, in a dagger to my heart, quote, the Supreme Court has instructed that Loper-Bright does not call into question prior cases that relied on the Chevron framework, end quote. As such, this Ninth Circuit panel believed that it could not go against Zizoni, even if it wanted to. Pretty devastating holding, made pretty quickly, with very big implications for post-Loper-Bright litigation. And also, that Supreme Court quote that the Ninth Circuit is relying on was talking about the Supreme Court's own prior precedent, not the lower circuits. Just saying. In this decision that never ends, the panel then addressed the asylum application that Mr. Lopez filed, which I'll go through as quickly as I can, but this was a very long decision. First, the court concluded that Mr. Lopez's application was untimely and didn't warrant an exception to the 1-year filing deadline. Quote, neither youth nor ignorance of the legal requirements for asylum constitute extraordinary circumstances. End quote. Nor did Mr. Lopez present evidence of a learning disability sufficient to warrant an exception, even assuming that such an argument had been exhausted. On to withholding of removal, quote, as to past persecution, the agency concluded that the harm Mr. Lopez suffered in utero did not constitute past persecution because it was not motivated by animosity on account of his familial relationship with his mother, end quote. The Ninth Circuit affirmed the denial here, but only based on that intent, that is, the intent of the father. Had the father been intentionally targeting the fetus Mr. Lopez, his claim wouldn't be precluded, at least under this decision. So that's kind of wild to remember. No sufficient future persecution facts shown either. Monster of a decision. Judge Sanchez concurred and dissented, but I've gone on for far long enough. So in sum, this is a long and complicated decision that's very important for immigration attorneys for many reasons that are mostly negative for non-citizens. And that is Lopez v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.